There are no existing safety standards regulating the sophisticated software and systems that will be controlling an autonomous vehicle. Although the Department of Transportation and NHTSA have been working on guidance and beginning the process on some rulemaking, their focus has been primarily on eliminating regulatory barriers. So I wanted to ask Ms. Chase, do you share my belief that NHTSA needs more encouragement from Congress to focus on safety during these early days of testing and deployment?
Madam Chairwoman, thank you for the question. Yes, we most certainly agree with you. In fact, you know better than anyone else that even when Congress directs the Department of Transportation to issue a rulemaking, such as the rearview camera rule, it takes about 10 years. We started that battle 10 years, soup to nuts, and then we wound up even having to sue the administration to release the rule because it was caught up in the OMB. So we most certainly need more authority for NHTSA, and that includes the imminent hazard authority, which is lacking right now, so that when there are problems on the road, NHTSA can act with accuracy and deliberacy to get these vehicles off the road. Additionally, NHTSA needs the ability to issue criminal penalties when needed, when executives have knowingly know that there are problems with the product that they are putting on the road. Thirdly, Congress needs to direct NHTSA to remove the civil penalty cap that currently exists for penalties. So NHTSA needs to do more, but it needs Congress to tell it to do more because it is not acting on its own, and there is tremendous frustration among the safety community that they continue to issue these voluntary guidelines. We're now at 4.0. If they started back at the time when they started doing the voluntary guidelines with rulemakings, we would be on the path to having minimum performance standards for some of these technologies, but that hasn't happened. So the frustration that was expressed in this room should be in part directed toward the regulatory body that is charged with making our roads safer for everyone. And we encourage Congress to move forward with legislation that includes regulations so that these technologies are put on the road safely.
Thank you. Mr. Hinkle, why does the deployment of autonomous vehicles pose different challenges to consumers' access to the courts than traditional vehicles?
Thank you, Chairwoman. Automated vehicles raise a number of unique issues regarding the way we consider the liability framework regarding how these crashes are going to be investigated and handled. One of the most important, though, is by the removal of the human driver from the equation and replacing it with a manufacturer's developed an automated driving system. You have a corporate entity that is now in tight relationships with things like the ride-hailing companies or the others that are going to be utilizing their vehicles in order to deploy this technology. That raises significant changes to the way forced arbitration is currently employed across the country today. Right now, if I'm in an Uber or a Lyft vehicle and I'm going down the road and that Uber driver runs a red light and causes a collision, I can still have recourse against that individual driver. But Uber has repeatedly raised their forced arbitration clause to try to shut off the ability to even ask the question whether they bear some responsibility in those situations. We saw this most recently in Pennsylvania. Uber raised their forced arbitration clause to prevent an individual who is seriously injured from even asking the question whether they should be responsible for these situations. It's not that we know for sure, definitely, that Uber should or should not in those situations. That's a contested open question. I think that there's a lot of different lawyers on both sides who have very strong arguments regarding that. But Uber didn't want to answer the question. They don't want to know what the law is. They just wanted to go away. And so they've invoked their forced arbitration clause and tried to make it go away. Just like they invoked their forced arbitration clause against all of the drivers out in California that tried to hold them accountable under a similar framework out there. In California, they successfully invoked their forced arbitration clause. When those drivers lined up to say, all right, you want to do arbitration, let's go to arbitration, they didn't pay the arbitration fee. They don't want to go to arbitration. They don't want to go to court. They don't want to know what the rules are. They don't want anything. Forced arbitration is used as a get-out-of-jail-free card. It's a way that we don't know what the law is regarding automated driving and automated vehicles. And that's one of the most significant changes that I think is present in the automated vehicle space.
Thank you. 5 minutes goes pretty fast. I yield back.